for joining us for the last episode in our first series of Law in Life. Today we're going to be exploring estate planning when you have a family member with a disability. I would like to acknowledge the Darkin young people, the traditional owners of the land we are meeting on today, and to acknowledge their elders past, present and future. I'm joined today by three very experienced panellists in the area, Fiona Wicks, Nick Ketley and Melinda Arnold. I'm going to ask each of you to introduce yourselves to our listeners and to also give us a little bit of an idea of your background in this particular area. I might start with you, Melinda.
Okay. I'm Melinda Arnold and I'm a mother and a carer to an adult daughter with a disability. She's 24 years old and she has Down syndrome, she's profoundly deaf and she's also autistic. Mm-hmm. So she's quite challenging to look after, but I support her on a regular basis. She lives at home with us and I organise all her NDIS funding and plan her daily needs.
Yeah. Thanks, Melinda. And Nick, you also have some personal experience in this area, don't you?
Yes, I'm Nick Ketley. I'm a lawyer in our Wills and Estates planning team, specialising in estate planning and estate administration with a particular interest in the disability sector. And I have a family member who has Down syndrome that I have some experience in too.
Mm-hmm. Thanks, Nick. And Fiona, I know that this has been an area you have been very passionate about for all of your career. Would you like to share with us your background?
Yes, I'm Fiona Wicks. I'm a solicitor and the team leader of the Wills and Estate Planning team at Aubrey Brown Lawyers. I've been a lawyer for around 20 years, but the last 5 or 6 years I have specialised in estate planning and wills and estates. And my interest in people with disability and difference and working in estate planning around their needs arose for me after I spent some time away from the law and actually did some work directly with people who primarily were at the stage of early adulthood, late teens, looking to transition from living dependently with family and carers into independent living settings, and mostly working with people who were on the autism spectrum, people who had behavioural and communication disabilities. And my background prior to law was in developmental psychology and cognitive neuroscience. So that's really where my interest and passion comes from, appreciating just the differences don't mean incapacity, they just mean difference. And when I came back to working in law after that time away, I was lucky enough to work with a firm that allows me the ability to do that area of passion for me, and something that I feel very strongly about, encouraging people to appreciate that there is always something that can be done, and to receive the feedback every time that you do when we talk to people about this sort of thing, that it is, oh my gosh, it's so wonderful to have found someone, we didn't realise this was possible. So that's the sort of thing that makes my workday worthwhile for me, and that's why I have continued to do it, and I'm really looking forward to doing more of it over the coming years.
Thanks, Fiona. I'd like to explore with you who needs assistance or who benefits from assistance in this area.
Well, if I might start, although I am the person who doesn't have a family member with a disability, I certainly have done a lot of work both outside of the law and in my practice as a lawyer with people and families with people with a disability. I guess I would say it crops up in two spaces. Primarily the one that is for the family and the carers who you will, when talking to people, often identify the thing that scares them the most is, I am the one who knows, I am the one who does, and when I can't and I won't be able to, what will happen? And in fact, I really got my interest in this area from doing some interviews myself with older people who were raising children with a disability. At that point, I had no insight, no empathy to what that reality looks like, notwithstanding that I did know people who had that situation, and that made me realise that there's something about raising people with a disability that people have either got not the time to ask for some assistance outside of the disability bubble, or they don't think people will understand, or sadly they think that that's for mainstream life, and when you've got somebody in your life that has a disability, it doesn't work for you. All of that stuff that works for everybody else. And so I think it's primarily for people who have that situation where they are thinking that there might be nothing they can do, worried about who will provide for my loved ones when I'm not here, and talking to people who have some experience and insight in relation to that, even if it's just to know that when the time comes, you can do it, is really liberating, I think, for them. And so I would say it's that cohort of people that primarily will get the benefit of what we're talking about today.
And I've been organising my will with Fiona, and we're just currently looking at that part with my daughter as well, because I haven't thought about it, and she's led me to actually think about it. It's like, well, what are you going to put in place for when you go? Because you always think it's far away. That's never going to happen.
And did you find that you were inclined to put it off because you were unsure of how to approach it, or what the answers might be?
Yeah, definitely, because it sort of gets put in that it's a little bit hard, and it's like, oh, well, I just can't think about that right now, and not knowing, what it looks like, what to do, and how it actually works, and having someone to explain it to me will really help.
Fantastic. And Nick, you have started to do quite a bit of work in this area with Fiona. What types of things do you suggest to people when they come to you and they do have somebody with a disability in their family for them to start to consider and think about?
Yeah, so there's two areas, as Fiona identified. There's your own personal estate planning as the carer, to make sure you've got the facilities in place for when you're no longer going to be taking on that responsibility for the next generation to take on that role. And then there's also the estate planning for that person with a disability themselves. So first thing, with your own personal estate planning for the carer, there's many things you can put in place. You need to have the right people to be able to take on that role, know who you want, and have the will in place to make sure that it does get there, whether that be through a special disability trust will, which is a special will that's designed to make sure that that person with the disability can still receive an inheritance, but that they don't lose those benefits that come through the government, so disability support, NDIS support, things like that. And then there's also their own personal estate planning to make sure that their assets of that person with a disability get to the right people. They've got the right people making those decisions for them through legal decisions, health and lifestyle decisions. And particularly for the person with a disability, having a will in place for them that leaves their estate to the people they want can be so important. If you think of a situation, say, where one parent has caused that person to have a disability and then disappeared from their life, if you leave it to intestacy, that parent's still receiving half the estate, and that just isn't right. Or you have a situation where you've got one parent who's looked after that person their entire life, sacrificed their own freedom to make sure that that child was looked for, and then to have them either miss out or only get that half while the other parent's flaked off has had nothing to do with that child, is just not right. So having the right documents in place to make sure that you know what's going to happen will happen is so important, because leaving it to the law can lead to very unintended consequences that can be detrimental to that person with a disability's wishes.
And I think that's a very important thing for people to realise when they, again, will probably not have thought that this is ever relevant because I've got a person who's got something about, and I think it's probably important that we make it clear that we're talking, in talking disability in this sense, we're talking about cognitive disability that affects a person's legal capacity to make legally binding documents. And that's not a fixed and finite black and white cut-off line, which some people might think it is. But in a situation where someone does not have the capacity to make these documents, they can still be a person who has some considerable wealth that they have inherited or that they have received. And the example I think you were alluding to, Nick, was one quite tragically where the father of the child was the person who intentionally caused the motor vehicle accident injuries for the subject with the adult with the disability. And in law, if you die without a will, the rules we lawyers refer to as the rules in intestacy will decide, just based on where somebody sits in a family tree, who gets what, and based on a strict set of formulas as to percentages. And so that example that Nick gave is one we encounter quite a bit, where people think there's nothing they can do, and what is ultimately going to happen is the person who has been, for want of a better word, the bad person, the bad actor in this situation, is going to get half of whatever is there. And not to suggest that anybody would be thinking that it's about the money, but it really does become about the principle. And that process of being able to access the court and the legislation to have a statutory will made for you in anticipation of your death, or even after your death. I've had cases recently where people have adopted children that they've cared for or fostered who have intellectual disabilities, and then the person has passed away thinking they've done the right thing by formalising the parentage, and they've left a will, but they haven't seen a solicitor with the right level of understanding around capacity and how to properly provide for a person who's got a disability in a will, and ended up with a will that would have consequences, meaning that each of these children would ultimately receive money that would mean in their own pockets, which they wouldn't have the ability to control. So the place it could end up being needed to be controlled by is the trustee and guardian, which isn't anyone's idea of the way things should best happen. And so going to the court and saying this is a will that, for all intents and purposes, should have been made to provide for these people to hold their inheritance in this sort of vehicle, and the court will make a statutory will after the death of a person on that basis. So those are the sorts of legal mechanisms that a lot of lawyers, to be honest, don't really practice in or are aware of. I certainly wasn't before I came back into this area of law after my time away. And again, I think just for people to know that these things are there, and that there are things that I didn't think were there may be other things that could help. And again, essentially, I think just both from the point of view of a person who has a disability that wants to participate in their own decisions, that's certainly an area that is maybe because of my background, my personal passion, and I spent quite a bit of time working with people who've got communication differences or disabilities around understanding what they can do and getting sound instructions and documents to support the fact that what they've done is validly done. Again, that's, I think, as Nick said, they're the two main areas that we would focus on working.
Nick mentioned that a key part of this is identifying the right people to have in the relevant places in the estate plan to make sure that things are going to flow after you've passed away. I'm interested to hear from you, Fiona, and you, Melinda, about how that process works and who the right people might be.
Yeah, and I think, Melinda, in your example, and it's a common example, there's often the next generation who might be the siblings of the person with the disability, who have obviously always lived their life with this as our family, and they know that this is my sibling, and at the end of the day, I think they always know that mum or dad, or whoever the responsible adult in the household is, does all of this, and don't necessarily think at some point I will need to do all of this, although when you ask them, they'll say, of course I will. So it's identifying who those people are, usually people within the family network, and then helping them appreciate how it works, both what is done by mum or dad at the moment and how it works in terms of what will happen under this document with you as the person who's standing in the position of being able to make those decisions and legally hold things and look after things on behalf of in your case, your sister. I suppose there are considerations around who's the rightful person and competing possible interests, and so being sensitive to that. And you've got examples where the other parent is involved but isn't as primarily involved and perhaps wouldn't be suitable or want that level of responsibility. So it's always a very tailored and sort of personalised exercise, and you do end up getting to know more about the family and the individuals than you might in other sort of estate planning type settings. And from the part of the person, you need to be comfortable in some way in being open and honest with the solicitor about what the concerns and the different personalities are, so that you can get some assistance from people who are experienced in saying, okay, so that person probably might not be right for the role, but they could have another role. And I guess in your case, it was really looking at the one who's old enough and the one who's got the right sort of mindset, but then also knowing that having a professional in there, or someone who's not necessarily that personally involved, because particularly with wills for providing for a child who's as an adult got a disability in special disability trust terms, has some statutory requirements in terms of how many people are needed to be the trustees of such a trust. And so again, there's a combined, I think, effort of planning from the personal side and who are the rightful people and what are the roles, and then who and how could it work with a professional or an objective outsider to support, so that no person is left doing it all by themselves. And I observe that in a lot of cases, that's a very different scenario to the scenario that's been at play, say, for the mother or the primary carer, who has often largely done it by themselves.
So Melinda,
Yes.
in looking at that in your own personal position, what type of things did you consider, or are you considering, when you're looking at the people you want involved in the future if you're no longer able to be involved at the level you are?
I think like my main focus is that my daughter would have the people that are in her life on a regular basis, that they will be there to look after her. And like Fiona's saying, I guess I'd need to have a few people, because that's something I've not thought about as well, that are possible options. Because like you said, you could allocate that to, I could say, well, I want this person to look after her, but I need to have a few people that maybe are considered, and then they can discuss that and have that guidance as well to go, well, this is what's involved, because there's so many things to consider, and it's managing her NDIS funds, it's also doing all her planning, and it's with her pension as well, like how's all that going to be managed. So yeah, it's definitely something that I really need to take the time to plan out those people that are going to support her.
And avoiding any disruption. Yeah, that. Then the other thing I think is primarily, insofar as possible, designing something that avoids disruption to familiarity and disruption to routine, because those are, as they are for all of us, things that are very close to your heart. And if you could avoid doing it, you wouldn't. But in a situation where somebody is living with the level of disability, say, for instance, with Melinda's daughter, it would just be unthinkable that that person has to move out of that place where everything is familiar and comfortable, and no one would want that. But without doing the planning, the position would be, in the first instance, that people would have to fight to get that thing that should be the right thing to happen, because the alternative would be everything sort of flips over to being directed by the statutory bodies. And whilst they have a very important role for people who don't have loved ones and a network of support such as this, and certainly 50 or 60 years ago they were really it, that's not the way the world is now. And the more people who can take things into their own family and their own realm and save the time of the people who are working within New South Wales Trustee and Guardian in our state, but the equivalent in other states, is really important, I think.
Mm-hmm. And Nick, with your clients, when you're advising them in this space, do you advise them that once it's done, it's a set and forget exercise, or is it something that should be regularly revisited?
Look, with all estate planning, it's always something that should be revisited regularly, just to make sure that what you've put in place is still relevant. People change. Some people, the person you chose to take on that responsibility might have moved overseas, and that would cause far too much of a disruption. So it's always something, I think, that you might not necessarily need to change what you've put in place, but always just making sure every few years that what you have put in place is still relevant.
Fantastic. I'd like to just talk about the benefits of having all of this in place. And Fiona, you've touched on some of them. Melinda, what do you see are the benefits for you and your family of having a proper estate plan that takes your daughter's disability into consideration in place?
Yeah, I think I see it as incredibly important now, especially discussing it, because it has been something I haven't thought about in the past. And yeah, as I get older, I've been thinking about it a lot more. So yeah, it's definitely important to think about who and all the things that are involved in looking after her. So yeah.
And from the lawyer point of view, what other benefits do you see for your clients in having this all put in place and properly formalised?
So peace of mind, knowing that you do have those documents in place to take care of your loved ones, and that when you're no longer there to look after them, there will be someone there to make sure that they can continue to live that lifestyle and have that support that they need.
That's right. And I think certainly from the lawyer perspective, because we more than, say, the carers and the lay people have the experience of what it is like to deal with a statutory agency like the New South Wales Trustee and Guardian, where everything would end up as a default if you didn't do this, then the benefit that the people who don't have to deal with the trustee and guardian will never know is that they don't have to deal with the trustee and guardian, with all due respect to the trustee and guardian, who do perform a very important function for the people who need it. But as Nick said, making the peace of mind of knowing that it is documents and legal authorities that you've put in place that are properly considered and appoint the people that you know are the right people, and you know that because of the personal commitment and love around the person, you are never going to get that when you're moving to a statutory body. And so it's the peace of mind that you've chosen the people that you want, and therefore no one will have to deal with the arm's length body who doesn't have any real idea about who somebody is. And often people who do have to deal with trustee and guardian, this sort of space, will say we are feeling like we're nothing but a number. And that's understandable. The volume of things that the New South Wales Trustee and Guardian has to deal with is immense. And so it's that taking yourself out of being on that sort of wheel and making a decision that keeps everything the way you've always known that it works, is personalised and within the realm of the people who are the loved ones and the caring ones.
Yeah.
Thank you, everybody. I think that my key takeaways today, and this isn't an area of practice that I have any experience in, is that it can be dealt with. It can be dealt with in a way that is probably a bit more straightforward than what people might expect. And a big part for me of any area of law that we practice in is if you are helping people to manage their expectations and understand their role in situations, it means if the situation arises, things are much more seamless because people are just ready to step up and, you know, things can continue. And I think the very important point you made, Fiona, is for a family member who has a disability, being able to keep the status quo in place for them if a primary carer is no longer around is very, very important, because it you know, assists with lessening the disruption that that might cause to them. So thank you to all three of you for coming along to talk to us about this today, and thank you for sticking with us with our Law in Life series. We really appreciate your support, and we would be most grateful if you would push this out on your socials, encourage family and friends to watch, and thank you once again.